And what a good act to follow, because this really is the future of the Democratic Party. We need young people, we need all people, we need to be tolerant. And I say that as someone far more aligned with Mike Collier on issues of abortion than, say, a lot of the people supporting Planned Parenthood. And I think Planned Parenthood is key and important, and I think we must save women's health care, including the right to abortion. But on the other hand, there's room in the Democratic Party for people like Mike Collier and Andrew White and me. And I say that blatantly because it's, I think, a follow-up on women's issues to what was just said, that we can have our own disagreements about the degree to which and the rhetoric we use, but on the other hand, we need to embrace people who feel, I think, more along the lines that I do, which is it's personal choice. And the fact I may have personal beliefs doesn't stop me from advocating for every woman's right to have a choice. And there's room, I keep saying it, there's room in the Democratic Party for me, or I wouldn't be here. I feel strongly about it. And I start off that way because with the diversity we need and need to increase, both in terms of every kind of person that there is, I've started talking more about the need for tolerance in people's beliefs. Because really all we're talking about is the rhetoric that is used. Because what's boiled down to divisiveness and meanness and mean-spiritedness in the country from the top on down has resulted in acrimony that isn't necessary. And let me also therefore echo the comments that we don't have to mandate who's going to be the President of the United States from the Democratic Party right now. We need to have tolerance there as well. The one thing I would correct, actually, is I'm not an advocate for impeachment right now. I'm an advocate for teaching everybody what the rules are for impeachment, so we are not deceived by people who tell us there aren't sufficient articles, there isn't sufficient evidence right now to impeach. I want to arm each of you with sufficient evidence to know that this is a political process, and a lot of political decisions need to be made about when is the appropriate time to file articles of impeachment, vote on them, and then send them on to the Senate. And everybody's got an opinion on it. Adam Schiff, who successfully prosecuted the last two successful impeachments in history in the 21st century. Yes, Congressman Adam Schiff knows how to prosecute impeachment. In each case, built a consensus or built momentum and knew how to politically get his impeachment articles passed, and he knew how to build consensus in a divided Senate to also get them voted on. He is the opposite, therefore, of those who tried to impeach President Clinton and impeached him successfully in the House and then failed to prove their case in the Senate. The House acts as a prosecutor. They bring the articles of impeachment, usually through the House Judiciary Committee, but that's not required. You'll hear all these pundits on TV telling you how it must be. They're just telling you how it has been in certain specific cases. It changes over the years, and there are now streamlined rules that allow, for example, an impeachment to occur, or two impeachments to occur simultaneously with all the investigation that goes on, or 5 impeachments investigated at the same time. There are no limits on investigation of impeachment in terms of numbers. Therefore, you find in the history of the United States, numerous people were investigated for impeachment. Some never got to the issue of being voted on by the House. Some were voted on by the House and resigned before they got to the Senate. Some got to the Senate and were on the brink, probably, of being convicted and resigned. So there's all sorts of possibilities. And one of the lessons of the Clinton impeachment is it is a process that if you know what you're doing, you file and you see what happens, not negligently, not stupidly, that you have a political idea in mind. So the prosecutor in the Clinton impeachment was Lindsey Graham. He was then a congressman. He was one of the House managers. By the way, when you hear the word managers on TV, it just means they're a prosecutor. They're somebody selected by the House. And he decided that impeachment was a political process. He read up because there's clear law. This isn't what I say in the book is well documented. If you hear otherwise on TV, it's from people who do not want the law to be the law. The law of impeachment is developed over 19 cases and the instructions from our founding fathers. The precedential law is very clear, and the Clinton case, for example, is precedent. And I want to give you one precedent that's very important. Clinton was prosecuted using as precedent judicial cases of impeachment. That was controversial. There was a debate through the years. Can presidents be prosecuted via use of judicial cases? Because every successful impeachment that went to the Senate and is a conviction in the Senate is a judge case. No president has ever been both impeached in the House and convicted in the Senate. Let me repeat that. No president has ever been impeached in the House or convicted in the Senate. Nixon didn't even make it to impeachment. He saw the handwriting on the wall and he resigned. He knew what was happening. Andrew Johnson, quite unpopular, had succeeded Abraham Lincoln, for goodness sake, was of the opposite party, and the Republicans came back in a very nasty mood when they came back to try to impeach Johnson. But Republicans, during the impeachment trial, because Andrew Johnson was impeached. That means the House voted on articles of impeachment the way a grand jury would indict or a prosecutor would decide to charge. But Johnson was acquitted in the Senate because 7 Republicans, called recusants, 7 Republicans chose to save that presidency along with the Democrats in the Senate. So there are instances in the past historically where people cross over lines to do what they feel is the right thing to do. They did destroy their careers, each one of those 7 men. They destroyed their careers, but they are honored by folks like JFK as Profiles in Courage, because one of the Profiles in Courage is devoted to those 7 Republican recusants when Kennedy was talking about people who do right. Lindsey Graham decided that since it was very difficult to impeach Clinton solely for lying about a personal affair, decided to find out what are the true criteria for federal impeachment in the United States. And a lot of research was done, and a lot of reading was done based on the Nixon Watergate hearings. At the time of Nixon, there was a bipartisan understanding of what impeachment meant, and it was based on a bipartisan committee formed in 1974, and it's produced a brilliant report that makes it very clear what are the grounds for presidential impeachment. And one of the things it relied on was all of the judicial cases of impeachment, because there's one standard for impeachment. It's called high crimes and misdemeanors. It's a specialized term of art. It doesn't mean a crime, and it doesn't mean a misdemeanor. Let me repeat. High crimes and misdemeanors is a term of art. Our founders developed it from British law. British law, high crimes and misdemeanors involved basically crimes sufficient to go off with your head. So those were crimes. They involved capital punishment. Unless you were a commoner. If you were a commoner, they just put you in jail for life, cut off your hands, did bad things to you. But if you were a lord and you were convicted in impeachment, and by the way, impeachment could be anything the king decided was treason. After the fact. Ex post facto laws are great, no due process. That was England. That was the king's rule, even including King George. And in England, other or high crimes and misdemeanors meant a crime against the king. And it was anything the king said it was, but it had to be a crime. And the way it was made a crime was, he just said, well, you committed treason. He just said it so, and they had a very broad law of treason. Well, the Founding Fathers changed all that. They were experienced, many of them lawyers, many of them barred in, that means at the bar and licensed, from England. They studied law at the Inns of Court. They understood history, they understood law, and they did not want to have a king who had the power to retroactively decide, you've committed a crime, I'll call it treason, off with your head. As a matter of fact, if you read the Declaration of Independence, it reads as an impeachment document. The Declaration of Independence is directed at King George. It's not directed at England. It continues to talk about how George did this and George did that, the king did this, the king did that. And the reason is, at the time in the law, the king was England. He owned the country. It was his to do with as he pleased. And when the Founding Fathers met and debated impeachment at the Constitutional Convention, they didn't really care about the judiciary. What they cared about was an authoritarian leader who was going to become the President of the United States, and they were mostly concerned that he would be bribed by a foreign power, or he would commit treason and betray his trust to a foreign power, or that he would be so crooked or so incompetent or so negligent, which requires no intent, or so bad a person that they wouldn't be able to survive with such a president. And so impeachment in the United States requires harm. It doesn't require intent. And if you disbelieve me, then you should read the first impeachment case in history that resulted in a conviction. The first impeachment case in history that resulted in a conviction was in the early 19th century, early 1800s. And it was of a judge appointed as a federal judge by George Washington, a fairly beloved judge who had served during the Revolutionary War. And there weren't that many federal judges back then, and it was a big deal. But he'd gone senile. He appeared to be drunk on the bench. And when he did rule, he would prevent people from having appeals. That's bad. He'd prevent them from putting on witnesses. He disallowed the U.S. attorneys from appearing in his court and putting on evidence, and he seized U.S. government property and gave it to friends of his and folks he knew. He posed a danger, and he did whatever he wanted, and Jefferson sought to impeach him. Adams did, sorry. It goes over both of the presidencies. And his impeachment trial, he didn't appear. It's not a criminal trial. It's not a criminal trial. It's not a civil trial. It's a political trial, and it's understood as such. There's no double jeopardy that applies, and the only penalty, you're removed from office. Criminal's independent of it. Civil's independent of it. All that is aside. This is a trial for the sole purpose of saving the United States from the harm created in the Founding Fathers' eyes by a president or any high U.S. officer who poses danger to the United States. It's as simple as that. All of the hooey you hear on TV from people who think they understand, they're just repeating what people have been arguing back and forth in impeachment trials over history. But the first impeachment trial in history that resulted in a conviction of Judge Pickering, the man was defended as insane. The defense was, he didn't intend to do what he did. He's insane. Didn't matter. He was convicted because he was harming the United States and posed great danger. If anybody says that a crime is required, there was no crime committed by Pickering. He did a lot of wrong things. If anybody says that intent to do wrong is required, that you have to prove that the high officer intended this man was incapable of intent as a matter of law, and the defense by his son. The man didn't appear for trial. You have no right to appear or not. You will be tried by the Senate whether you appear or not. He wasn't represented by counsel. His son represented him. You have no right to demand counsel or somebody pay for it. You can. Everybody's been represented by counsel since Pickering. It's a political process, and the purpose of the process is solely to protect the interests of the United States. So you don't have to prove it's an emolument. You see guys on TV saying, oh, we've got an emolument, therefore we've got impeachment. No. Proving emolument, proving a crime, won't get you impeachment. You have to prove harm to the United States. So if someone has committed a crime and it does not lead to harm to the United States, that's not an impeachable offense. You run a stop sign, not enough. You commit even a worse crime, not enough. But if the crime happens to also be something, or some negligence or failure to do something, do I need to sign that? Okay. Good. Ed, you may need to sign. If anyone says to you that intent is required, they're wrong. And it's not a lengthy book, I must say. It's considered nonpartisan. I've been speaking at law schools and allowed in and allowed out. So it's an important concept. And really what I want to do is arm you with the arguments so that when Adam Schiff says it's time, because Adam Schiff has been complaining, and others have been complaining, that there's a rushed judgment on impeachment, that we shouldn't distract. I listen to Adam Schiff. I can disagree with him about when is the time, but I think that there's a whole bunch of people getting into power and already in power who know exactly what impeachment means, and they know what flexibility they have. And there are a number of other people who've just been voted into office who said they'd be willing to impeach or consider articles of impeachment. And so there's going to be a time where there will be an overwhelming move where harm to the United States is recognized. And I think Adam Schiff has shifted his conversation since the election. Before the election, this past November, Schiff was talking about let's wait, let's wait, let's wait. I've been following what he has been saying on the TV shows and the evidence that he's been mounting, how he has begun to interpret what he expects to be coming from the Mueller investigation. And I think he is slowly, intelligently building consensus. I'm not saying I agree or disagree right now with his past statements if they apply today, but what I'm saying is he'll be a barometer, more so I think than almost anyone else, of where things are going. Because I guarantee you, if anybody has a brain, they will put Adam Schiff on the committee that is going to be involved in at least prosecuting the case in the Senate. Usually it's the House Judiciary Committee that does a lot of the legwork. Sometimes it goes to rules because it hasn't been appropriately worded. But there is no rule that requires it go to the House, to the Rules Committee, to the Committee on the Judiciary. There are no rules for impeachment. It's kind of like a knife fight. And the rules are that the House has the sole power to impeach, and the Senate has the sole power to try the case as judge and jury. Now, where do I get the word sole? Well, the word sole appears in the Constitution only 2 times. The House's sole power to impeach, and the Senate's sole power to try the case. There is no other sole power granted to any branch of government in the Constitution. There's checks and there's balances. For example, the president can veto, and Congress can overcome a veto. There is no one who can set aside an impeachment. The president cannot pardon an impeachment. That's in the Constitution. The Supreme Court, under Justice Rehnquist, wrote a very important decision that said the Supreme Court cannot review an impeachment. When the Constitution says it's the sole power of Congress, House sole power to impeach and the Senate sole power to try the case, what Rehnquist wrote, the House knew what the Founding Fathers knew what they were doing when they said sole. And this is a U.S. Supreme Court case that actually contains the word sole means soul. That's the phrase. The word soul means soul. It's that obvious. And I want to give you that. I know I've handed out articles of impeachment. I was asked to write them for Law 360, which is a popular lawyers subscription magazine. And over the summer and in the fall, they asked me to write 3 articles. One on the one you have in front of you, where they asked me to draft sample articles of impeachment. And then they asked me to draft, to give a little commentary on the Clinton impeachment. And what the wonderful lessons are. I'm sure it wasn't pleasant for the Clintons, but I will tell you we have some wonderful lessons. And the underview lesson I'll tell you, because I teased you about it earlier, Lindsey Graham was trying to find a way to go after Clinton that would somehow fit within the law of impeachment, and he found it. He found cases, multiple cases, of judicial impeachments where the sole grounds or the main grounds were bankruptcy fraud, that's personal misconduct. Bankruptcy fraud. Taking bribes, that's pretty personal conduct, although some of it may have affected their other misconduct. And conflicts of interest. And other misconduct like tax fraud, all by judges, none of which was considered official misconduct. Because there were those who said, in defense of Clinton, lying about an affair really has nothing to do with the administration of justice or with being a president. But technically, even if this issue of whether he committed perjury, it's possible, but he was convicted of demeaning he was not convicted, he was impeached and acquitted on the issues of causing harm to the country. The impeachment was a prosecution that was technically correct. It used judicial cases and marshaled them to say, you've done something wrong, and in this political climate, you are a bad example to the country. A very weak impeachment case. In my opinion, the weakest impeachment case in the history of the United States. The weakest, and I've read a lot of them. I've read all 19 of the ones that resulted in either convictions or resignation. And there have been hundreds of impeachment cases researched and worked on. The weakest one I've ever heard of is the one against Clinton, because Clinton clearly caused no harm to the United States. And in essence, the Senate's vote made that pretty darn clear. There were senators who thought he'd done wrong, but they couldn't see how it harmed the United States. And therefore, the Clinton impeachment is a wonderful example of how Lindsey Graham is hoist on his own petard. Lindsey Graham has made clear he understands what the rules for impeachment are. Ironically, as things have developed over the last very long 2 years, we don't have any of these nuanced issues left to really discuss, because the main thing that the Founding Fathers intended impeachment for was betrayal of trust to a foreign power. That was number one. And the book contains some really interesting quotes from the founders, because there were folks, as they were debating impeachment, that changed their mind. And one of the more eloquent ones was a guy named Gouverneur Morris from Pennsylvania, who really able to turn a phrase. And in changing his mind about the need for impeachment for the President of the United States, he jokingly, but serious in his joke, recalled an instance of recent history. It had happened in the late 1600s. It was recent for these guys. King Charles, after the Civil War in England, King Charles had been bribed by Louis XIV of France to basically give up the Netherlands, convert to Catholicism, and sell out his country for a lot of money and the help in getting some land he wanted overseas. He just sold out. And it was called the Treaty of Dover, which was a public treaty, but a lot of the deals and the money that exchanged hands and the promise to convert to Catholicism, which he never did, Converting to Catholicism in England in the 1600s would have been just, I can't tell you how unpopular that would have been and what it would have resulted in. But what Gouverneur Morris said was, what convinced him that impeachment should exist in a new form for the President of the United States was examples of what he knew from history. Because they were talking about giving the president a big salary and so he wouldn't be bribed. And so Morris said, we can give him all the money you want. What he wrote was, even the wealthiest of men can be bribed. And he said, recall that Charles was bribed by Louis XIV. This is in the Madison papers that outlined what was happening at the Constitutional Convention. He says, after all, Charles was bribed by Louis XIV. And Charles has, as it were, a fee simple interest in the entire kingdom of United Kingdom, in all of Britain. In other words, the man who owned more real estate and had more money than anybody in the world at the time was bribed for a couple of £1 million by his, I guess, brother-in-law or cousin-in-law. That shows what the Founding Fathers feared. They feared betrayal of trust to a foreign power. And so what you have in front of you, in rather order of preference in terms of what's serious, is worded in the way and is based on impeachments throughout history. For example, the word treason won't appear in the document you see. Why? Treason requires intent. Nobody's ever been impeached for treason. There's guys been impeached and convicted for treachery, however, because treachery is just causing harm to the United States and betraying trust. So, you will find examples in the book, for example, of the guy who waged war on the United States, Judge Humphreys, who decided in the Civil War that he was taking the South side, but decided not to abandon his federal position, and from his bench as a Confederate judge, not yielding his appointment from Lincoln, and thereby depriving Lincoln of an appointment and getting rid of him, he began to seize lands and imprison Northerners and do all sorts of bad things for the Confederacy. He was waging war against the United States from his federal courtroom. Did they plead treason? No. That would require intent. He didn't even show up to his trial. Of course, you can understand that. He was busy. He was very busy waging war. But he was convicted, and he was convicted of the treachery, and it was considered a high misdemeanor. Not treason. U.S. Grant's Secretary of War was impeached. He took money and sold it. He took money through an intermediary to him and his wife, lots of money, for a trading post. The sale to be in charge of a trading post. Was he impeached? Were the words bribery there? No. Why would they not try to charge bribery for somebody who was bribed, clearly, and took money to give up a trading post, a lucrative position? It requires intent. That guy didn't show up for trial either. He was tried for demeaning the office. The same type of allegations against Nixon and against more speciously against Clinton. It's offered to you, therefore, to show you what the wording would be also. You can plead intentional conduct, but you don't have to prove it. And so Congress usually chooses not to plead obstruction of justice. They plead impeding justice. Sometimes they use the word obstruction. But Mueller does not need to indict, and the president need not be indicted or convicted of a crime of any sort to be impeached and convicted in impeachment. Because impeachment conviction is merely removal of office. It has nothing to do with criminal behavior. And there are those who've been impeached, convicted and removed, and then tried for the crime, the underlying conduct and the crime. And there are those who've been impeached after having been tried for the crime. But you can't just plead someone has been convicted of a crime. That article of impeachment is insufficient, and we know that because there's cases of judges who were convicted of crime, and the catch-all argument at the end, you've been convicted of a crime, even if it's a crime such as bribery, that won't do. You have to prove the underlying facts. And they have to be proven in the context of causing harm to the United States. I know I've said it about 13 times, but it's about harm. It's not about intent. And every time you see somebody on the TV talking to you, just throw some tomato at the TV because it's just not true. I hope you're now then a little armed, because when you have friends or enemies, if you have somebody tell you, we can't pursue impeachment, we have to wait for X, Y, Z, it's not true. Politically, maybe we should. Politically, we need to build the will. We need to build the strength. We need to make sure the timing is right. But you can have an impeachment trial go on for a long time, or you can do it very efficiently, as occurred in the Clinton impeachment, where for political reasons, everybody wanted it done, and it was December, January, and it was over. The investigation can be short, or the investigation can be long. Until January, now, we weren't fixing to have people who had subpoena power. Therefore, there wasn't much to be done in calling for impeachment. In impeachment, those committees have subpoena power. That means they can get to the truth. And if something happens in the Mueller investigation, no matter what, we know that we do rely on Congress to do what it thinks is best. So, that really is, yeah, other than telling you to throw tomatoes at people on TV.
What case do you think, if Congress, the Democratic Congress, were to impeach, what would be the strongest case from what we know now about Trump's behavior that would convince enough Republican senators to vote for impeachment?
What is the strongest case for impeachment? My opinion is betrayal of trust to a foreign power. My second level would be conflicts of interest and having financial interests that cause him to do wrong, and the biggest wrong, in my opinion, would be betrayal of trust to a foreign power. But the betrayals of trust need not be motivated by conflicts of interest or funding, but so they'll overlap a lot. But I think betrayal of trust to a foreign power. I think a close second to that big category would be failing to defend the United States in our electoral system. We're under constant threat. He knew he was advised we were under constant threat, and he failed to defend us. And continues to do so, for goodness sake. And that could be negligently done or intentionally done. But the failure to defend the electoral process is something that I think the founders... Yes, sir.
To me, what you're saying is, no matter what we do, no matter what Congress do, he can keep that in court for years.
No, that's a really good question. I didn't mention that. The question was, is what I'm saying, or is it possible that Trump could keep this impeachment fight in trial, in court? Can't go to the courts. That's what makes it different. No, the president has no control over how Congress does its business. Our problem is Congress. Impeachment is the sole power of the House to impeach, which that could well happen. The real problem is, what would the Senate do with the trial? And what's interesting, I didn't mention, and I'm so glad you brought it up, in the Senate trial of a president, the House acts as judge and jury, as it always does. But there's a figurehead. It's the Chief Justice of the United States. And the Chief Justice of the United States presides over presidential impeachment trials. But he has no power. He's a figurehead. Everything that's decided like a judge would decide is decided by the Senate voting. They vote as a jury on jury issues, like impeach or convict on specific articles, And instead of the Chief Justice, who does preside, the issue is one for the Senate on admissibility of evidence, what's hearsay, what's going to come in or not, and they decide the rules. And the Chief Justice is there just to look pretty, literally, to make it look pretty. There and there.
I had a question regarding what evidence can they use against him, right? Because during the campaign, he literally invited Russia to come in and release Hillary, hack Hillary's emails, right? Can they use that as grounds for impeachment?
Prior to being elected, can a federal officer be impeached for conduct prior to being elected? We have an answer now from the last couple of federal cases. The answer is yes. And Judge Porteous, who was a 21st century conviction of a federal judge who was about as crooked as you can imagine, Judge Porteous lied to the FBI. That's really a bad idea. He lied to the FBI after he was a nominee and before he took office. As a nominee, he lied, and he lied big time about his financial. He was crooked, and he was in bed with the bail bondsman, literally with the guy's sister. But in addition, he was a crooked state court judge. And let me go backwards here a bit. One of the articles of impeachment included his state court misconduct, which was before he was even nominated. And I always narrowly interpreted that, very conservative, because I'm a conservative person when I'm writing what I hope will be a history type book. But since I wrote the book, Adam Schiff, who prosecuted the Porteous case successfully, Adam Schiff wrote a wonderful essay in the Washington Post which talked about why he wrote the articles of impeachment the way he did when he charged him and what their significance is. So we now have a record, and the publishers agreed that when the next edition is done, we will put in Adam Schiff's words. The man prosecuted the case. He says it goes beyond, impeachment goes beyond just being a nominee. It goes back to what you did as a campaigner, or before. But the other way to get to that is a typical lawyer's, I don't want to say trick, typical lawyer's tactic, which is continuing course of misconduct. In other words, you can do wrong and maybe it's not actionable, one could argue, but lying about it is actionable as all get out. And so it's the cover-up that hurts people in impeachment as well. But yes, there are two cases. One is the Porteous case, and the other is an earlier judicial case where a guy engaged in misconduct, and that was cited in the Porteous case. So that question's answered, and this gentleman has been patient.
Just a quick one. Can the Senate decline to hear a impeachment case? Just say nah.
No, the Senate cannot say nah, but they can have a vote and say nah. They don't have to, they can have a quick vote and say no. It takes 2/3 to convict. And the Senate has always done its duty. Sometimes people didn't quite understand the order of things. The first impeachment in history was a little confused. They didn't quite have it down right, and it was of a senator. And the senator was a real estate fraudster. He was a swindler. He peddled securities. He bought his way out of the revolution, and his father gave him a lot of